the order was passed on the 11th, attaching my entire bank account.
File, yes, leave granted. File it.
We'll come.
We'll stamp punch it and then give to your lordship.
Let it appear tomorrow.
Appellate side.
Original
side. Let it appear tomorrow.
Tomorrow. Some precedence we will give.
Let it appear tomorrow. If not tomorrow, day after tomorrow, original side will be taken up. Commercial, non-commercial?
Non-commercial. So that's tomorrow, not if it could.
Tomorrow, appellate side, there are hardly any matters. So in all probability.
Otherwise, we'll mention what you notice.
My lord,
Great.
my lord, may I have my lord's leave, my lord, to file an appeal, my lord, without the certified copy. It's an order dated 17 September 2025, my lord. Last time. Right?
Thankful that we got notice for this.
Observe notice.
Yes, of course.
My lord, I have to mention on matter. My lord, I have received a notice from my lord the other side. It's regarding my lord that matter. My lordship had extended my lord the suit regarding my lord board, West Bengal Secondary Board. Mr. Mitra and Mr. Ghosh were appearing. Your lordship had given directions, my lord, to them, my lord, to file the affidavits. My lord, the time has lapsed.
Yes, so you've received notice of what?
See, notice, my lord, for mentioning, they have not mentioned him today.
Then don't mention, please. Yes.
My lords, I am praying for my lords kindly to mention a matter regarding filing of an appeal without the certified copy, my lords. My lords, the order dated is 6 May 2025. This is an originating summons suit regarding dealing with the property of a trust.
Were you party to the
My lords, I
matter?
had filed an application to be implemented as a party, but my application was rejected. Against that, my lords, I wish to file an appeal.
Yes, but why should we grant you leave for an order dated 6th of May?
My lords, I have filed and request before the department. However, my request was denied.
When?
My lords, I have mentioned this matter before, and my lords have directed me to go and try my luck again with the department. Accordingly, I filed a request again on 18th of September, but as of date, I have not received any communication from the department, my lords.
Rejected হলে তো তোমার right of appeal থাকবে। জিজ্ঞেস করো তো, জিজ্ঞেস করো। শোনো, যদি দেখো অকারণে নিচ্ছে না, লিভ দিয়ে দেবে।
Grateful, my lords. My lords, I'll mention this matter once again at 1:50.
You don't have to mention, we'll do the needful. You be in touch with our court officer.
My lords, if my request is entertained, my lords, I wish to file a stay application along with that. If my request is
You will be informed by our court officer.
Grateful, my lords.
My appeal.
My lord, I'm appearing on behalf of the respondent. My lord, I'm being led by Mr. Krishnaraj Sakkar, senior advocate. He's
Mr.
Krishnaraj Sakkar. He was addressing your lordship on the last occasion. That was on
আজকে কি আজকে তো
This was lordship.
non-commercial.
Yes, lordship kept it, Millard. Today, Millard. We had to finish it off. Mr. Bachawat has concluded.
Before non-commercial.
Before non-commercial indicated in the list, Millard.
Yes.
Your lordship, I am seeking for a note today. Your lordship is on his legs before court number 10. He's occupied in some matter. So he had
First matter in the list is was
I understand,
giving
Lord.
precedence. This is not right, sir. We don't appreciate this.
We have nothing more to add, Millard. It's he to complete.
Not today, chalo.
Kindly, Millard, takes it up tomorrow, Millard, 10 Millard. I am waiting, Millard. Yes.
Mr. Ghosh, we can't promise anything. We'll try.
Millard,
Not too many matters will be taken up over the last 2 days. He was his new application. In all likelihood, it will be taken up.
Tomorrow, Millard, it's the appellate side.
I know. Then day after tomorrow is there also. Likhe na ekta order. This matter was directed to be listed effectively as the first matter today. Stop. Learned senior counsel for the respondent
Yes.
was making submission. Stop. Paragraph today. Accommodation is sought for on behalf of the respondent on the ground that learned senior counsel is busy before another learned court. Stop. Paragraph, list this matter, or let this matter stand adjourned for the day. But retain its position.
Controversial matter to be instant. Item number 1.
Lord, I appear on behalf of the appellant. This matter was mentioned, my lord, for extension of interim order. Interim order is till the end of September, my lord.
You're for the appellant?
I am for the appellant, my
Who's
lord.
I appear for the respondent number 1, lordships.
Respondent.
For the respondent number 2, your lordship.
Subject
Very
matter of, sorry, my lord.
Dekho. The interim order that is in operation in this matter, is due to expire on September 30, 2025. Stop. The matter has been mentioned on behalf of the appellant for extension of the interim order. Paragraph. Since we have not been able to dispose of the appeal, let the interim order continue till the end of November, 2025, or until further order, whichever is earlier. Stop. List the appeal under the appropriate heading. It's a paragraph. Immediately after the puja vacation.
Lordship will
Great.
fix a date, lordship.
Hmm?
Lordship will fix any date.
27, 28, whatever.
Lordship, whatever is convenient for lordship.
October 24. Immediately December on October 24,
Lordship.
2020.
Lord, instead of 24th, can it be on 27?
Yes, 27.
24th is Friday, possible.
October 24 is a Friday.
This was Monday, I was praying.
Very well.
First day after reopening. So
Yes, 27.
grateful, my lord. Extremely grateful to you, lord.
Number 2 and 3.
My lord,
Yes.
in this matter, item number 2 and 3, Lordship had directed this matter to the mediation,
Yes.
but mediation has failed between the parties. So I would just request the date may be fixed after vacation.
Very, very true. You're for
Lordship, I am for Ramji Agarwal.
Ramji.
Yes, Lordship.
Lordship, I appear on behalf of the defendant, Saurav Agarwal.
Learned advocates for the parties tell us that the mediation between the parties have failed. The mediation, that mediation between the parties has failed. Paragraph. We have gone through the note of the registrar, original site, dated September 19, 2025, appended to which is the failure report dated September 12, 2025. Stop. Paragraph. In view of the aforesaid, let the এটা কি একটা combine order হচ্ছিল? হ্যাঁ, combine. Let these two appeals be listed under the appropriate heading on October 29.
Much obliged.
The application item number 4.
My lord, I am for the petitioner, my lord. The affidavit is service. It is the application for recalling, restoration application, recalling of the order dated 22nd May of 2025, Lordship. The affidavit service and
They served me a copy, I think.
They have not served.
I
They
have
have
no
served.
copy. Probably he served upon the contempt.
Restoration application,
That-
give him a copy. Give-
Give me a copy, man.
Don't read it now, read it in the evening.
Sir.
But I have said
Where is the, huh?
GA1.
Dekho. You are out of time.
Lordship, there is delayed 43 days delay, Lordship. It is mentioned in the Lordship paragraph.
Yes. This application has been taken out for restoration of CC 11 of 2025, comma, which was dismissed for default on May 22, 2025. Stop. The delay of 43 days in the there is a delay. There is a paragraph. There is a delay of 43 days in filing this application. Stop. Causes shown being sufficient, comma, the delay is condoned. Paragraph. Having heard learned counsel for the parties, comma, we are satisfied with the explanation furnished. For absence of learned advocate for the petitioner on the day the matter was dismissed for default. Paragraph. Accordingly, the order dated May 22, 2025, comma, is recalled. Stop. CC 11 of 2025 is restored to its original file and number. Paragraph. GA1 of 2025 is disposed of. Paragraph lists the contempt application under the appropriate heading after the puja vacation. After the puja vacation 2026.
Grateful. While
I am appearing on behalf of the petitioner appellant, Your Lordship.
Yes, have you given those particulars in your application?
Yes, all the particulars are provided, Your Lordship.
দাও তো এটা তাহলে ফ্রাইডে রেখে ও তো ওই জাজমেন্টটাই গভর্ন করবে আশা করছি। Where did he last reside? Where was he residing? The deceased?
Last residing at within jurisdiction at Vivekananda Road.
And properties are where?
Only one property is outside at Uttar Pradesh, Your Lordship. The intestate heirs are the wife, the widow, daughter, and son. The son is the executor. The wife and the daughter has given affidavit of consent, which is
Citation has not been issued.
no, Your Lordship. The consent are at page 39 and page 43.
And exactly the same as Probichandra.
Yes, Your Lordship.
We will just still go through the application one. Keep it on Friday, you know. Keep it on Friday. Jate first matter, je keynote debe diye dao. We'll pass the.
Your
order
Lordship,
on
in
Friday.
that event, may I indicate the page number?
Yes, yes.
That would be helpful.
Yes.
Your Lordship kindly sees paragraph 5
First,
at page 4.
Where's the will?
The will is at page 13. Page 13, Your Lordship.
Yes.
And that property is at mentioned at page 14, serial number Roman 4.
Yes.
The affidavits of consent are at page 39 and page 43. I apologize, page 39 and page 44. Page 39 is the widow's, my mother's affidavit of consent, and page 44 is my sister's. Your Lordship, the impugned order is at page 57.
Is that we have seen? That's a 4-line order.
Yes, Your Lordship.
Very well. Okay, can we change to-
And the
Very well. Come back. We have heard learned counsel for the appellant. Stop. List this matter. What order is it? Under the heading for orders. Under the heading for orders, comma, for orders tomorrow. Tomorrow date ta diye dao. Before appellate side matters.
Great.
First item.
Great.
Hey, shono. Yes.
I do not speak.
This matter appear for the respondent. Appellant, my
This was sent to mediation.
One second, Ravi.
তোরা কোনো ফোন পেয়েছিস মিডিয়েশন থিয়েটারে কোনো ফোন পেয়েছিস?
হ্যাঁ দাদা, গতকাল তো হিয়ারিং ছিল, কিন্তু গতকাল আমাদের
ও আমাদের কোনো ফোন করেনি, আমরা কোনো ফোনই করেনি।
কন্ট্যাক্ট করতে হবে, you have to contact the center.
Yes.
Malad appointed Milad mediator. Malad send this matter to mediation.
Yes.
Milad, we have not received any call either any notice from the mediation center. We have
Lordship, my
contacted.
instructions are Honorable Retired Justice Subroto Talukdar has been appointed as the mediator.
Yes.
In fact, yesterday was the date fixed for the first sitting of the
They
mediation.
say they don't have notice of
We
it.
don't have notice of it.
Maybe you don't have proper instruction, Mr. Dal.
No, Milad, I had just Milad asked, requested him to call the client 2 minutes back before the matter is on. The client also said that they have
Lordship,
not received any.
perhaps I think the usual court
Oh, because of yesterday. Yesterday, how could anything be held?
and perhaps
Well, Milad,
Lordship, it is up to the parties to get in touch with the mediation
Yes,
center
yes.
for
We had been Milad.
Let it be listed after the vacation. In the
Milad,
meantime,
there were 2 interim orders by a lordship.
that will continue. Whatever is there will continue.
Lordship, the only modification, Lordship, which I would humbly pray, Lordship, I'm handing over this order. Lordship is already taking up that order, my lord. Lordship, may I kindly draw my lord's attention to the second page, third paragraph, Lordship. There was a direction on me not to file my returns, Lordship. The last day is 25th. Nothing would turn on it, Lordship.
No.
The returns of the 3 companies who are the appellants before my lord.
If you are injuncted by the court, will you be penalized by the registrar of companies?
Lordship, it is the income tax department, Lordship. We have to file. I do not know, Lordship.
No, if the court says don't
Milad, by
file,
paying additional fees of rupees 100, it can be filed till the next financial year. Milad, section 91,
92 and 137.
137 of the Companies Act.
Because
And Milad, if the court has Milad directed Milad, no point.
it is under the court order you are not filing.
my lord,
It has to be
my
maintained, Milad. Just
instructions that come, Lordship. I will.
Very well, you have made your submission. Next. That's all.
My lord, that is the only portion, or else.
No, we are not, because without applying our mind to the facts of the case, we did not apply our mind as we have recorded, because you had agreed for mediation.
My lord, that was there.
Issue. Learned, you are for?
The respondents. Milad.
One. Respondent
Respondent number 1.
Learned advocate for the respondent number 1 tells us that read order dated August 27, 2025. Stop. Para. Learned advocate for the respondent number 1 tells us that his client has not received any notice of mediation proceeding. Stop. Paragraph. Learned advocate for you are for?
Appellant.
Lordship, I am for the appellants.
Appellant. Appellants.
Appellants.
Appellants tells us that Honorable Justice Subroto Talukdar has been appointed as the mediator, and yesterday, bracketed date was the date fixed for the first sitting. Stop. However, because of the deluge that the city experienced, nothing progressed. Paragraph lists this matter once again 1 week after the Puja vacation under the same heading. Stop.
1 week of
The interim orders recorded in the order dated August 27, 2025 shall continue until further orders. Stop. Paragraph on the adjourned date. The learned mediator is requested to file a report or interim report.
এটা একটু বাড়িয়ে নেবো কেননা ভেকেশন পড়ে যাচ্ছে মিলাদ only one request মিলাদ can it be the adjourned date মিলাদ later because মিলাদ the vacation
weeks
will
after.
not be there মিলাদ
3 weeks after the vacation. 3 weeks.
3 weeks after
My lord, we had sought leave to file the appeal without the certified copy. The certified copy is now ready, lordship. May I just
Put
file
in
it?
this
Dilo.
3 weeks after 3 weeks
Certified copy দিয়েছে?
No, I will be handing it over, lordship. My
Will
advocate
be. Then we will be recording when you will be handing over.
lordship, my advocate.
Give
on
it.
record.
আচ্ছা লিখে দাও তাহলে certified copy of the impugned order filed in court today be kept with the records. ও দিয়ে দেবে তোমাকে।
And lordship, my instructions are we had already informed them about the mediation process, lordship. Anyway, I'm grateful.
3 weeks after
এই ফোন নাম্বার নিয়ে নাও নলেজ নিয়ে ফোন নাম্বারটা নিয়ে নাও আচ্ছা
I'll ensure.
Item number 7.
I am appealing for the appellate, my lord.
I am for the respondent number 1, my lord.
Order 7, Rule 11 has not been allowed, my lord. Order
appeal
7
has to be heard. Appeal has to be heard.
Very short point, my lord. We had taken the point of barred by law under Order 23, Rule 1, Sub-Rule 4. We have filed a suit. You have withdrawn it without liberty to file a fresh suit on the same subject matter. Now, my lord, there is now what your lordship will fall for consideration is whether subject matter can be used interchangeably with cause of action. My respectful submission will be, my lord, cause of action is different. It's a bundle of facts. I may have a cause of action in respect
My
of
lord,
one.
on that point only, my lord,
Yes.
appeal to be heard.
File informal paper book.
My lord, another appeal, my lord.
Yes,
is
my
a
lord,
connected,
That I
connected
don't
appeal.
know, my lord, why it has not come.
APOT
There are
number
two different suits, two separate applications.
You are defendant in both.
Yes, yes.
Very well. Let that
and
also
I
be
am the
listed.
respondent number 1 in both.
Plaintiff in both.
Plaintiff.
Let that also be listed. But immediately after the vacation.
Yes.
I am for the respondent number 2.
But I can give the number of the other.
Give the number.
APOT number
Ashun.
240.
240.
After vacation করেছিল না
এটা হচ্ছে কত নম্বর? 7.
কোথায়?
This appeal is directed against
Only thing, my lord, we have not filed any written statement, my lord. The suit should not be transferred to the undefended.
that is only fair, Mr. Sen.
Usual order.
Appeal is directed against a judgment and order dated August 11, 2025. Oh, both the applications were disposed of by this common order.
Common order.
Oh,
Yes, by the common order.
August 11, 2025, whereby two applications filed by the appellant herein in the two suits filed by the respondents herein, for rejection of the plaint under Order 7, Rule 11 of the Code of Civil Procedure, have been dismissed by the learned single judge. Paragraph. The appeal has to be heard out. Stop. We are told that all papers that were available before the learned single judge are annexed to the stay application filed in this appeal. Stop. Paragraph. List this appeal immediately after the Puja vacation, along with
APOT 240.
পেয়েছেন বললো যেটা
APOT in 240 of 2025. And my lord, the suit could not be
হ্যাঁ
as
এটা দেখো 25 comma under the heading এই এটা কিসে দেবে বলো তো হিয়ারিং অ্যাপিলটাই শোনা হবে
very short matter, my lord, your lordship.
put it at the top কোন হেডিং এ দেবে বলো ঠিক আছে অ্যাপ্লিকেশন থাকুক as the last item under the same heading
Obliged.
new application but last item
It will be taken up as application.
we'll hear out the appeal stop it is understood that both the appeals will be heard out on the next date paragraph let the two suits not be transferred to the undefended list till the disposal of these two of the said two appeals.
My lord, your lordship has fixed any date, my lord?
The other date, 24th, reopening day.
My lord, 24th is the reopening, my lord.
Yes.
একটা ফ্রি হয়ে যাবে
Is it a holiday?
হাইকোর্টের পরের দিন
আচ্ছা 20 এটা কি কমার্শিয়াল না নন কমার্শিয়াল 29th
29.
তাহলে immediately after না বলে একবারে listed on October 29th.
I was led by Mr. Surojit.
Very well. We can see him.
That is why I made it.
Your Lordship, I appear for the petitioner appellant, Your Lordships. Lordships, my other side is not there. Oh, yes, Mr. Ghosh is here. Lordship, I'll commence my arguments.
The matter is very short, but I am the person who was in default, being a plaintiff, not to have lodged the writ of summons for a long time. But thereafter, there's a change in the administration of the plaintiff. Now we have come in, we have become wiser. We filed an introductory application to which they filed, apart from filing an affidavit in opposition, they filed also an application for rejection of the plaint. It is after that we have filed an application for extension of time to file the writ of summons.
Now tell us very frankly, Mr. Tiwari and Mr. Ghosh, can this not wait till after the
Yes,
vacation?
absolutely, because it's an extension of time to file, lodge the writ of summons, which has been allowed.
We will keep it on the reopening day if you are available on that
Your
day.
Lordship, the only difficulty from my side, Your Lordship, is that if we are to allow this appeal to be prolonged, the time for filing of the written statement has already begun to run because the writ of summons with the plaint attached has already been served on us.
I'm not standing in the way.
Your Lordship, we will have to continually seek adjournments there, which, or we'll have to seek extensions of time over there before the learned master by making applications in the suit.
You'll have to do nothing of the kind if we grant you that extension of
Yes,
time.
Your Lordship. So if Your Lordship...
Which we will. If you have asked for the dismissal of the suit?
Yes, Your Lordship.
If you succeed, no question of filing written statement.
Precisely.
If you don't succeed, we'll extend the time for you to file written statement. Full stop.
Yes, Your Lordship. That would suffice.
Yes.
And if Your Lordship, with great candor, Your Lordship, whilst I do not want to lose my 2 minutes of thunder before Your Lordship, with great candor, I will very humbly submit, if Your Lordships are minded, and if Mr. Ghosh is able to at least take instructions on this, if the costs are increased, because the delay was of 12 years, and the costs imposed are of rupees 50,000 only. If the costs are increased, because
how much you want?
Your Lordship, there was a previous matter and a previous judgment which holds the field on the subject.
NP.
Yes, NPR Finance, which was delivered by...
How much did I award?
In a 6-year delay, Your Lordship had awarded 5 lakhs of costs.
Not taken to Supreme Court.
Not taken to the Supreme Court. 2.5 lakhs payable within 2 weeks of the date of the passing of the order. Because Your Lordship was of the view that stricture should be there.
That is not laying down any law, the amount.
No, it is
Certainly not, certainly not. Certainly not. The law laid down
Very
in
well.
the indolent litigant.
That instruction also I can take it.
Yes.
At the reopening.
They'll take that instruction.
My point is, I'm coming as Keshava saying I'm ready, if only 5 villages could be given. If 5 villages can't be given, then I will turn to the other side. I'll say, Suchagre na dashyami bina yuddhena Keshava. Your Lordship will translate.
What is this tikka?
This is the bhasma and then kumkuma on top of it.
Yes, kumkuma, Ma Kali, Ma Goddess Kali.
To Lord Bhairava and Ma Kali.
Heard by Ravi monthly. Any particular temple? No.
No particular temple. Personally done at my home
Where's your home?
after conducting my personal pujas, Your Lordship.
Hey, Isho, listen now. Learned counsel for the parties candidly tell us that there is no such urgency as in the matter. There is no grave urgency in the matter, and the matter and the matter may be heard immediately after the puja vacation. Stop. Paragraph, let this matter be listed on October 29, retaining its position. You take instruction, how much cost? Huh? We are not recording that.
Kindly don't record. I've understood and I appreciate the candor.
That will put an end to the
Yes.
thing. Same order in the next matter. There were two suits or what?
No.
There were two applications.
Two
My
applications.
application and
Oh,
my
I
learned
His
friend.
application has been rejected and my application has been allowed.
That's why two deals.
Very well.
Grateful, Lordship.
Obliged.
Item number 10.
For the appellant.
Milord, I am
I appear for the respondent, defendant in the suit.
ঠিক আছে ঠিক আছে There is no application. There is no application. They have not served any application.
Milord, I am Milord led by Mr. Shoroshish Dasgupta. He is Milord waiting in online. If your Lordship Milord kindly permit me, Milord.
I appear for the defendant. I have been allowed to appear online.
Why?
But my surrounding areas of my house is entirely water.
Oh, still submerged.
Still submerged.
Oh
Still
my God.
submerged. Couldn't get out
Yes.
of my house.
Milord, I am Milord led by Mr.
It's for the appellant.
I am Milord for the appellant. I am Milord
We are
led by Milord,
respondent.
Mr. Shoroshish.
You are for?
Respondent led by Mr. Dasgupta.
Oh, you are led by Mr. Dasgupta.
He is Milord led by Saurojit Dasgupta. I am Milord led by Shoroshish Dasgupta.
Yes.
He is Milord waiting.
But
Respondent.
there is no application.
If he
Only memo.
Yes.
But if he has been allowed, I can see Mr. Shoroshish Dasgupta has been
There is no
allowed.
application. What will we hear? The appeal.
Yes, Lordship.
File your paper books.
No.
Yes, Lordship.
The memo to the.
May I, Milord, file our affidavit of service, Milord?
Appear করেছে সার্ভিস আর কি আছে
Amalgamated.
Well, our Lordship has to, the appeal has to be heard, but there is no scope for an interim order, so we did not file any application. But we can prepare paper book and that will come back.
Dismissal of a judgment upon admission application.
Oh, I see. Eviction.
Yes, eviction suit. I filed an application for judgment upon admission. It was dismissed by the.
Yes, Mr. Plaintiff Dasgupta. Mr. Plaintiff Dasgupta. We are giving direction for filing informal paper book.
Yes,
We'll hear it out immediately after the vacation.
Yes, great.
Mr. Defendant Dasgupta, agreeable?
Yes, well, absolutely.
1 week.
Very good.
1 week after vacation. November. Any day.
2 weeks after vacation.
Month.
This appeal is directed against a judgment and order dated July 25, 2025, where passed in GA2 of 2022, filed in CS 218 of 2021, whereby the plaintiff's application for judgment upon admission has been dismissed by a learned judge of this court. Stop. The appeal has to be heard out. Stop. Paragraph, let the appellant oblique plaintiff file requisite number of informal paper books containing all papers that were available before the learned single judge, within 1 week after the vacation. Huh? 1 week? 1 week after the puja vacation. Stop. All formalities are dispensed with. Stop. Since you are appeal for all the defendants.
Yes,
Both.
Both.
Since the respondents are represented by learned counsel, notice of appeal is deemed to be waived. Stop. paragraph with the application to make deemed to be waived. Paragraph lists the matter under the appropriate heading 2 weeks after the puja vacation.
I'm good.
Grateful. Great.
Lord 11, my lord, I'm for the appellant, my lord. I'm praying for a short passover, my lord. Mr. Mitro, Surojitnath Mitro is leading me in this matter, my lord. He's engaged.
Your Lordship, item 16 is my appeal, Your Lordship. Both may be taken up together.
My lord, short passover, my lord.
But I appear for the defendant, the appellant in this matter, in item number 16 and the respondent here.
Very well. Let this be passed over, Mr. Dashgupta. We'll see.
My grateful.
Right, please, your lord.
The appellant.
In this matter, I am for the respondents. We are for the respondents.
Mr. Anindu Kumar Mitra is online, I believe, he's appearing. Because of the water logging, he could not come to court. He's there waiting in the on.
No, he has joined. He has joined.
Yes. Give the connection ID.
Inside. He's there, he's waiting in the lobby.
So, let him.
He has joined, but your lordship, he has joined. His name is being shown in the list.
Is now, am I audible?
Yes, Mr. Mitru, you are audible.
This lordship, and it was defendant number 1 is registered trade union.
Mr. Banerjee, why can't this wait till what is the urgency?
Urgency, your lordship, is that in my injunction application has been disposed of. They filed an order 13 and rule 4. Now that has been dismissed, but while dismissing, certain orders have been granted in the nature of injuncting me for doing certain things. And now they are taking advantage of this thing and creating mayhem.
The connectivity is not good. You know our views, Mr. Banerjee. You know our views. We can't do justice like this.
So the urgency is that your lordship,
As
kindly
such, there is
stay
no
the part of
urgency,
the
my lord.
order.
Without hearing you, stay the part of the order.
Not at all. No. I want your lordship to hear us. What has happened, your lordship, without any relief being prayed for, in an order 13 and rule 4 from an ad interim ex parte order, injunction has been granted against me without any prayer being made. My interim
May I take over, Miller?
Yes.
See the judgment.
Hard by
Can you
both
see the
parties.
judgment? Can you see the judgment? And please come to page 3 of the judgment. That was the interim order pass after quotation. That is the ad interim order pass.
One second.
Order.
One second. Who is this Shantanu Chatterjee, a doctor?
No, lordship, he is the president.
He is the president of the union. Erstwhile president of the union.
Not a doctor.
No. He's
Yes.
the president of the trade union. He's a FMRI, All India Trade Union.
My lord, can you see the ad interim order which is set out in page 3 of the judgment? Accordingly, the defendant, officer, etc., restrained from creating any obstruction.
Yes, Mr. Mitro, kindly just give us 2 minutes. We'll just read the judgment.
Read the judgment. That will be my task. Will be easier. It is unusual. May I peruse the order?
We are reading the order. Kindly give us
Yes.
2 minutes.
No, don't interrupt you. I will interrupt.
Yes, Mr. Mitro.
My lord, Lordship has seen
Yes.
the identity what was passed several months back, the date, etc. That has been, does not prevent, does not say or interfere with any trade union activities. Can you see the order at page 3? It is minimum order, which is usual order, if I may say, passed in this kind of matter. When
Correct.
accordingly, the office bearers, etc., restrained from carrying on any obstruction of hindrance in the running of the business and working of the plaintiff company and his employees in Kolkata and throughout the state of West Bengal.
Yes.
That was the order. Learned judge held that no ground for vacating of that order has been made out. Then he should have confirmed the interim order and left the matter at that. If simply confirm the interim order, don't nothing further is required. Now, learned or honorable first court on its own, kindly can now come to page 5. He passed this order. Defendant also say middle of that page, say activity plaintiff is in violation of provision of Industrial Dispute Act. Look, is a case arising out of transfer of 6 employees within and dismissal of 2 employees, which happened in the year 1922. In the year 1922, the dismissed employees have referred their disputes to the labor court. Transferred employees, they can also refer if they want. Nobody prevents them referring dispute transfer. Now, my lord, chief defendants further say, if I not forget it, that by using the identity order dated circumstance as of 2024 October, now 1 year back nearly, as a tool of operation, plaintiff has prevented even normal trade union activities, which include protest, demonstration of dharam as of where? How have you obstructed? How? No particular nothing. And image, etc. proved undead. Defendants therefore say order dated should be discharged under varied. Learned that do not neither discharge nor vary. This is a vague thing. Now see the last paragraph is dangerous. Can you see the last paragraph of this page, which is very, very unusual. In the instance case, defendants have not been able to show any ground for his interim order injunction dated circumstance should be vacated. Record be vacated. Now, after that, please come to page 6. Page 6. Be that as it may, a trade union, its members have certain privileges and protection. Their rights, etc., have been taken full course of several judgments for the Supreme Court and the various High Court. Our Reserve Bank of India case is a leading case in our court. I got it, where industrial trade unions, legitimate activities, nobody wants to restrain, provided they act within the corner. Anyway, at the end of the day, unless there is any illegal or wrongful activity, like criminal intimidation, physically assaulting any willing member joining the regular office, or by directly causing loss to the business of different company, rights and privileges and protection available under the Act are not interfered with. On a close study of 1976 Act, I do not find any parameter, etc., contrary to 160A in the Dispute Act from the Employee Protection Employee. Now, please me not now see after doing all this, what Lordship has a further order. The transfer employees are not members of this trade union. The dismissed employees are not even alleged to be members of the trade union anywhere. Now, I'll show from their own opposition, it is their habit of creating disturbance and court passing an order against them. Now, similar to what order they have passed, this additional order without any prayer, anything, this order has been passed. This allegation, similar have been illegal. Employees trying to protect the willing employees. And hindrance, which is that there's evidence of that. Photographs that I'll show you not immediately. Alleged illegal transfer, etc. If the illegal transfer, alleged transfer matter has been referred to industrial dispute, nobody stands in the way. In fact, two employees who have been dismissed, they have referred the dispute to industrial tribunal. It's pending. Allegations and counter-allegations cannot be either held to be true or correct or false at the interrogative stage without there being any clinching evidence to that effect. Kaushik got page 7 of the judgment.
Yes, we are there.
It is at the same time as the correct that willing employees or paid company should not be intimidated or terrorized or subjected to any harassment or assault in course of discharging their regular duties. While it is also correct, registered union should be permitted to ventilate its grievance through protest, dharma, rally, demonstration, strictly in accordance with provision of the Act. Very good. Now see the next paragraph. This is nobody's case with that they are being disturbed. Now see the next paragraph. It cannot be said at this stage without further ascertainment that the version of the party is true, one party is true and correct, while that of the other is false or incorrect. It also settled provision that in a just deserving case, even if the parameters laid down in Order 31 Rule 4 are not strictly complied with, then also court for the sake of justice or discharge the order under Indian jurisdiction. Court can do, but court doesn't choose to do so. Then we tiny turn the page. It is the issue. In the aforesaid next paragraph, in the aforesaid facts and circumstances, to strike a balance, I clarify the order dated 7th October 2024 by permitting Defendant number 1 and his members from carrying out normal trade union activities. There is no bar. The interim order did not injunct them from carrying on trade union activities. Why it was necessary then? Carrying out normal trade union activities, like protest rally, etc. No materials have been given, and court has not held that employer company is interfering with the trade union activities. No. So beyond, but same should be done beyond the 50 meters, etc. Let them catch it, doesn't matter. The notice board, this second paragraph, this is very important. This is creating all problem. The defendants, however, will be permitted to display protest materials or protests or posters in the notice board maintained by the plaint company. They have been allowed to access. First order said don't go beyond 50 meters. Second order said after the said they would go beyond 50 meters. Second order said they can enter my office premises. And actually they are doing so because of this order. This is the opposite part. This is what we have come to your lordship for. Dependent and not members that dependent should not intimidate or terrorize any willing employees. Company from either joining the work or that injunction was there already. That simply identity order should have been confirmed. Then it is further clarified, it is below reading. Plaintiff shall not be entitled to take any steps or enforce any ban on the protest gathering. Really. This is what? This is a contrary to law. Contrary to law. Or the demonstration or dharma. If the same is carried out by defendant number 1 in a responsible manner, now who will decide that? Defendant number say what am I doing or doing in a responsible manner? Court doesn't define what is a responsible manner. Court doesn't define. It's for the that my submission is this: the court should have been pleased to confirm the interim order and say liberty is given to the defendant if the plaintiff interfered with the trade union activities, they apply. Give them liberty. If I actually interfere with trade union activities, then they can apply to court and obtain appropriate orders. But on my application, they're getting order. Number one. Number two, Milord Kanishi. It is not their case that this trade union are representing our employees. Any of the employees of this trade union are the members of this trade union, our employees. There no such case is made out. And now, can you see what is actually happening one by one? After getting this interim order, what they are doing, can you see? This is matter of record. Please come to relevant page. What are doing after the order? Please come to me, Lord. The order after page 538. That's order obtained in another matter. See, me, Lord. There, this trade union is making disturbances with others, and they are suffering orders. They have themselves annexed these orders.
Volume 4.
Now, please see page 31 of the state petition. Sorry, paragraph 4 of the state petition. And there are documents in support of that. After being emboldened by this
Yes. Yes, my lord. Yes.
Filed FIR. Very well then. Take his usual normal course. We will definitely modify to the extent that the order allows them to enter your office premises and put up posters on your notice board. That we cannot justify. What no? That is the order.
There are photos also.
We usually put up the notice board in the order after intimating the company that we are going to demonstrate, and that order is to be noticed, pasted up in the notice board. We are not doing this.
You cannot have access to their premises. You just cannot.
We don't need to have any access. We don't need to have any access. We don't need to have any access. Only that we are intimating them that on that particular day we are going to demonstrate, and that has been well circulated. The company is very well aware of the fact that this is going on. Only for the demonstration. And 50 meters away office premises from 50 meters. Question entering office doesn't arise at all. We are not entering the office. Never we enter the office as far as this demonstration is.
Now, with the photographs, the posters you annexed, can you read paragraph 4 and I'll show you the documents to demonstrate, to clearly prove that they are doing so. They are doing so. They are not carrying out.
They are not entering the premises.
Please see. We have annexes which are they are sending posters to our all employees.
Our chief,
all employees. See that he means how they're in that what the language, etc. How they're doing so. Paragraph 4, I just read what a summary of the things they're doing emboldened by this interim order. Petition seeking stay of the part of the impugned order with clarification and relief granted even without making application, etc. What is the ground? Respondent number 1 is using the said order to further stop and terrorize the employees of the petitioner company from doing their daily field work and activities of the meeting with doctors. They should post a notice.
Volume 1, paragraph 4.
Notice to the employees. They're not allowing my employees, salesmen, to reach a doctor's house. If several incidents have taken place where the respondent union members have again taken law in their hand by further physically and assaulting, stopping employees. This is not a bare allegation. We are not bare allegation. There are documents issued by them. Please see me not those documents. Please come to me not, take the volume 6. See me not page, the posters there. Kindly me not take volume 6.
752.
Volume 6. Now see me not what kind of posters they are issuing to my employees. volume 6, page 752. This is the poster. This is the language. অবস্থান বিক্ষোভ আক্রান্ত historic verdict চললো, enough is enough. Then on 3rd September middle at 2 p.m. we, the fighting members of the union, will give a resounding and befitting reply to about how management right in front of the establishment as the fight. At front of the agreement of the, that's exactly have done. Please turn to the photographs which are annexed. I'll just show, kindly Miller come to the photograph, page 758, Busso, 758. 758. This is not maintaining 50 as 50 meters. They're simply going. This is a photograph taken on 3rd September. See the turn the page.
You file the contempt application for violation.
We have
Why?
not filed.
Why?
Yeah,
If they are breaching that 50-meter order direction, you're entitled to file.
Yes, my lord.
That they have not filed indicates that you are not aggrieved.
No, no, my lord. We are aggrieved. That is why we have preferred this appeal. That
Your obvious thing would have been to go to the learned judge and say, look, they are misusing your order. They are not complying with the 50-meter direction.
Yes, my lord.
You have not done that.
Lord, we shall take
The order as such, we accepting that granting them access to your offices, that we will modify.
Lord, one more thing with
Now, Miller, please also see Miller, page 757. No, page 757. This is the posters they're giving to my employees. No interview to about healthcare managers at the doctor's premises. We salesmen go to doctor's chamber and try to promote our sales of medicine. No interview to be given. Which is that sending the posters to all the employees. Now, Miller, please see the other document that you see. Page, I'll give you the date. Page 754, Lord Shivasin, 754. Please.
Mr. Mitro,
Yes.
even if the learned judge did not add those two paragraphs saying that you will not prevent them from holding lawful this and that, they would still have the right to do anything that they are lawfully permitted to do under the Trade Unions Act. Now, if they are doing something which is beyond their right, as recognized by the Trade Union Act, then file FIR if they are doing something illegal.
Now, can you see if the order is contradictory?
File
Order
FIR,
allows them to come
go
near
with a
my
contempt application before the
premises.
learned single judge.
Order permit them to come to my premises and
That we
create
will stop.
disturbances.
That we will stop.
Then also, can you stop that?
We will stop that.
Yes.
We are saying so. We will
In
stop
addition,
that.
we shall now apply for contempt. But if I apply for contempt right now, they will simply say we are doing so.
You will not have access to their offices.
But we don't have any access.
Then you are not aggrieved if we delete that portion.
No. If, particularly, may I respectfully submit one thing?
Sir,
When
if you don't want access,
yes,
if we delete that portion which permits you to go into their office premises,
at the time of demonstration, my lord. At the
demonstration
time of
you will go into.
No. In the question of settlement or any other things, if we don't have any access, in that case it will be very difficult for us. Suppose they are asking us for a settlement.
No.
Only case of demonstration, only case of protest.
Look what the learned judge has said. Look, come to page, I think 8. Come to page 8. The defendants will be permitted to display protest materials or posters in the notice board maintained in the offices of the plaintiff company.
We are not doing that.
Then you are not aggrieved if we delete this sentence.
Yes. We are not doing
and
that.
Leave everything else open for
we
contempt.
will not go into the
FIR you have filed,
Yes,
that will be
Lord.
carried to its logical conclusion.
Kindly see 762.
In fact, my lord,
762 that they are barging in the premises and pasting notices.
We are stopping them.
Kindly see 760.
It's nothing on record, nothing on, it's a wayward submission. my lord.
And
Even
the second thing they're doing, issuing
your lordship-
posters to my employees saying, I don't attend the doctor's chamber persons. I've shown you the instance.
Mr.
they-
Mitro, that issue was not before the learned single judge. You go back with another application.
Not going,
Because they are our
that
members.
issue was precisely, that was the order passed.
That
They will
was the
not-
issue, my lord, before the
They will
learned.
not
We will,
act
we will delete that portion that permits them to enter your office.
Yes.
We will clarify that they will only be entitled to do such things which the Trade Unions Act recognizes, nothing beyond that. If they do something beyond that, you will be entitled to take all steps against them, including criminal complaint. All these we will clarify. And any further relief, go before the learned judge.
Lord, another,
Contempt, go before. We'll say so in the order.
Lord, just one more
Kindly
thing, Lord.
mention,
Another
kindly mention that in case of negotiations or any settlement, question of settlement, we have we must
Lord,
have some
settlement. This is always
Because
one
the office,
settlement.
we are debarred from entering the office.
This is not what their practice is. How to bring about
There's a
settlement.
question of negotiation. If they file serve a notice that there is a question of negotiation, in that case, my lord, we may have the access. Kindly mention that. Apart from the demonstration purpose.
Sir, they may decide to hold that negotiation somewhere else, not necessarily at their office.
Even if it is in the office.
Therefore, why would we want to go into their office?
No. We are not interested to go to their office.
That is what
We are
say.
interested to go as per the negotiation and settlement question.
But I did not a recognized trade union. I am not going to win a
No, it's a
negotiation with
recognized trade
them.
union, your lordship.
You will go only if they call you.
Yes. Yes,
Yes.
that is. But if we are barred from doing
No,
that, then
only
we
if
are-
they call you, they will go.
Yes. We are not going
And
into the premises.
Can you see the last paragraph also? Plaintiff shall not entail to take any steps. Enforcing the ban on the protest. What is this? Last paragraph, page 8.
Very well. Allow us.
This should be
My lord,
deleted.
my lord, in
You
fact,
know, in my humble servant, best order should have been, in my humble servant, ad interim order, just confirm. And with a clarification, this should not prevent the dependent from carrying a legitimate trade union activity if they are entitled to. That my
Very well.
submission is, dependent union is not entitled to carry on any trade union activities because none of my employees are their members.
yes, they are members.
They have no asset. They are not recognized trade union. Why? Is a habit. They are a habit to create like this, and they are. That may I show you the order they themselves disclose in their affidavit of opposition. Let's see the two orders. It is the habit. They create disturbance, then force the employer to come to a negotiation table and give them something. Please see the orders they have themselves annexed. Please. Two orders I'm showing you, Lord. Please see the page 538 and 540 orders.
Volume 4, volume 4.
Volume. See, and similar, and what order court has passed? Page 530, give the volume number.
Volume 4, sir, volume 4.
Volume 4. Can you smell it? See what is their practice? It is their practice is to.
What do you have to show? How can you show that that the plaintiff's employees are your member?
Yes, my lord, all are members.
No. Where is what material do you have?
No
Then I have to
statement in the
entire
petition.
thing there.
What
Then I
entire
have to-
thing?
Entire submission I have to make, my lord. My lord, they are the members, and we are espousing the cause of these members.
What do you have on record to show that his employees are your members?
Vacating application.
It is stated in the petition.
Show us. Why are you just making oral submission? It's all there.
My lord,
We have
today
annexed
itself, I have,
everything.
Show us.
Lord, we have annexed
today they are our members. They are our members.
Can you show where have you stated
Yes,
that?
yes.
That petition? Can you show?
Kindly.
Copy नहीं बनी. You have not been served.
Yes.
No, we have served it.
Vacating application take within the
In vacating application 591. Volume 5.
Where's your brief?
It's a brief take to nahi. We take application. Application for vacating application.
My lord, kindly see.
Yes, ma'am. My lord, kindly see the annexures by which it is in that we are all doing that as members
Volume
and
5.
we are doing this in volume 5. Kindly see the
Prima
annexures of
facie
the vacating
shows.
application.
So,
Vacating application.
vacating, yes. Vacating,
এটা কত
vacating application, yes.
না এটা তো স্টে অ্যাপ্লিকেশন
At page,
এই তো GHP আপনার, এই তো GHP।
volume 5, page 593. See the vacating application. And they have annexed these orders.
My lord, your lordship may kindly see that West Bengal Medical and Sales Representative page
641.
641.
Volume 5. 539.
Before that, they made any criminal cases, but these criminal cases were disposed of without any punishment being forked out.
Volume 5. That's the way.
641.
641.
What does it show?
641.
What does it show?
We have made a complaint to the officer in charge of the.
We. Who are you? Are you not Federation of Medical and Sales Representatives Associations?
It's the subsidiary of the Federation of Medical Representatives. It's a state body.
I see.
593.
Yes. Very well. This union has made a criminal complaint.
Criminal complaint.
We want you to show us that the plaintiff's employees are your members. Simple thing.
All the membership records will have to. All the membership records.
You should have brought it. Why do you come to assist a court without proper material?
All the materials we have to bring.
We don't need all materials. We only need such material as would indicate that the plaintiff's employees are your members. Come back tomorrow with proper.
They are more interested in negotiation. Negotiation more interested in. Negotiation.
If they are not your members, would you be entitled to espouse their cause?
No, certainly not.
Show us that they are your members. Come back tomorrow.
Yes. They have no averment to that effect. There is an averment to that effect. Is that so the petition have they made avert anywhere that there are members?
I will show to your lordship.
Members. And it is their practice to do so.
Where is in you have filed a vacating petition?
Yes.
Where is one line saying that the plaintiff's employees are your members?
Yes, I will show to your lordship.
No, show it
The petition
now.
is there.
Vacating petition is here. Show us.
593 is there.
Mr. Alim, is there any such averment?
There's no such averment, Lord. We have also stated before the learned single judge.
That is just we grounded chotto limited.
Kindly allow me one day, my lord. Tomorrow I will show it to you, everything, my lord. Whatever your lordship simulates. Where is my lord?
Because this trade union, the practice is to create obstruction.
Mr. Mitro, just to enable your learned friend to read the papers, which he hasn't obviously, tomorrow, please let us allow.
How to read the papers which are on record. We have all the papers are on record. Going from the record.
Yes.
And this they have annexed order have to see the practice to carry on this kind of obstruction, and then they bring the employer to a negotiation table.
A very important point, comma, which is factual in nature, comma, that arises is whether or not the plaintiff's employees, plaintiff's apostrophe S, plaintiff's employees are members of the defendant trade union. Stop. While the plaintiff says that its employees are not members of the defendant union, comma, the union says otherwise. Stop. This point is important, since if the plaintiff's employees are not members of the defendant union, comma, the union may not be entitled to espouse the cause of the employees of the plaintiff.
May I only add, I have submitted, there is not even an averment in the petition or affidavit that they are members.
Paragraph, Mr. Onindo Mitro, learned senior counsel appearing for the appellant oblique plaintiff, says that there is not even an averment in the pleadings filed by the defendants that the plaintiff's employees are members of the defendant union. Paragraph, learned advocate for the respondents oblique defendants seeks a day's time to obtain better instructions. Paragraph lists this matter. Hey.
আরে সেটা তো বলছি, এটা তো বলেই দিয়েছি, এটা তো বলেই দিয়েছি। শুধু দেখাতে হবে আমরা মেম্বার বলে কোনো জায়গায় ওই ওইটা দেখে
The interim orders continued for 1 year and they peacefully carried on business.
না না রেজিস্টার নয়, মেম্বার কিনা আমাদের এরা মেম্বার মেম্বার এই যারা ওয়াকম্যান যারা এ করছে, আমরা মেম্বারদের হয়ে কাজটা করছি। সেখানে কোনো অ্যাওয়ার্ডমেন্ট আছে?
This matter, kalke date দাও on such and such, before the appellate side matters.
Tomorrow appellate side,
Before the appellate side matters.
10:30 then.
Yes, 10:30 there's one for orders which will take 5 minutes.
Very well.
Immediately after that.
Grateful. I'm extremely grateful to your lordship.
Just show us that the plaintiff's employees are your members.
Yes, certainly.
Or that you have made such an averment in any of your pleadings.
Yes.
I'm grateful.
Mr. Mitro?
Yes, Milord.
Is there still water outside your house?
I'm totally in Venice. Even now in Venice. In all my garage, guard all ground floor, submerged. Ground floor, the furniture, etc. be removed from the ground floor.
I also experienced that yesterday. You may be aware that Deodar Street is notorious for waterlogging.
Yes.
There was knee-deep water on the ground floor, inside the house.
In the library.
In the chamber, my father's chamber. Yes.
Fortunately, my chamber is upstairs, but still water has receded, but still steps up to almost knee deep inside the house. And the Mandeville Garden, Suino Street, absolutely.
But by tonight it should go all together, and then tomorrow we hope to see you physically. Tomorrow, if possible, please come physically.
But I don't like the virtual appear. Doubtful the way nothing is happening.
Very well. Chal.
It's simply say the I'm doubtful that tomorrow there will be any better.
বুঝেছি আমি বলছি তা নয়, আমি বলছি আমার কি বিরাট লিস্ট করে দিয়েছো নাকি?
In the meantime, he should not enter my office premises. Kindly make the even if members
we'll do that. Tomorrow we'll definitely do that.
If
they can't show that that your employees are their members, then we may stay the entire order.
Then totally dismiss their case, but not totally impose ban on the plaintiff employer that we cannot take any steps against illegal if trade union is done. I'll show you from the orders they disclose that this is a business to create disturbance and then bring the employer.
বলো কি রাখো পাশাপাশি থাকলে নাম দিয়েছো?
Lordship, I appear for the told me that Mr. Surajitath Mitra sir, he is appearing for the
Somebody obtained a passover in the first call.
Yes, Your Lordship. Lordship,
then,
no copy has been served upon us yet.
Hey, লেখো তো, in the first call, on the request, in the first call, comma, on the request of learned advocate for the appellant, comma, this matter was passed over. Paragraph. In the second call, nobody appears for the appellant. Stop. paragraph lists the matter immediately after the puja vacation. Stop. If service has not been effected on the respondent,
Only the memo is appearing,
comma,
Your Lordship. Only the memo is appearing, Your Lordship. There's no stay application.
if service of all the appeal papers has not been effected on the respondent, comma, let the same be done in the meantime.
My lord, sir, item number 11, my lord, Shurojit, sir, Shurojit Mitra, my lord, is engaged, my lord. Kindly pass over the matter, my lord.
Next, 14. Come, Mr. Ghosh.
Mr. Ghosh will take the rest of the day.
Ask him. Rest of the day means till 1 o'clock.
Yes, Lordships have
After that, we break.
combination at 2 o'clock.
Yes.
Justice Roy has also got a separate list.
So you will take the rest of this half.
Kindly keep it on the 29th because that's a Wednesday, available after the vacation.
15 নম্বরটা 29th করে দাও।
Not deeply of October.
তাহলে ঘুরে আসি। Mr. Ghosh, we don't want to interrupt your argument after 3 minutes, so we'll rise and come back.
Well, good. 2025 2 SCC 417. And the award was set aside in this case. Everything has been upheld. All the principles laid down in those cases have been
Very
upheld by them. Now, will the judgment cited by my learned friend. আরেকটা আছে দাও তো ওই হরিশ্চন্দ্রের judgment দাও. Well, may I start with first the judgment cited by the appellant 2025 SCC online SC 956. কোনটা?
Last judgment.
হ্যাঁ, এই কপি দাও, নিশ্চয়ই ভুলে গেছি, সরি। এটা ওখানে দেখিয়েছি, other side.
Consolidated cost consortium. The operator.
In this judgment, my lord, up to para 22 dealt with the facts and the principles laid down in various judgments of Supreme Court. Not a single judgment has been considered. All that is said that this has been well settled by various judgments of the Supreme Court for setting aside of an award. It's only comes from para 23. To 29 really the judgment. 6 paragraphs consists of the judgment. Otherwise, facts of the case and what are the principles. And setting out the sections. Para 23. Scope of Section 34 of 1996 Act is now well crystallized by its plethora of judgments of this court. Section 34 is not in the nature of appellate provision. It provides for setting aside of an arbitral award, that too only on very limited grounds. Now, this contained in 2 and 2A of Section 34. It is the only remedy for setting aside an arbitral award. An arbitral award is not liable to be interfered with only on the ground the award is illegal or erroneous in the in law, which would require a reappraisal of evidence adduced before the arbitral tribunal. If two views are possible, there is no scope for the court to reappraise the evidence and to take the view that the view taken by the arbitrator.
Mr. Ghoshal has placed these paragraphs before us.
How does it help him? With respect to my learned friend,
Very well.
there is no way it helps him.
It
They're
will
all
not.
similar. Whatever I have said below, those principles have been reiterated. Then comes below your lordship's judgment in BBM Enterprise versus State of West Bengal. Well, your lordship in the entire judgment, I could not find your lordship has departed anyway from the principles laid down in accessory builders of saw pipes or Saming's case.
Thank God for that, that we have not departed.
So, Your Lordship, I don't know why it was cited, because it doesn't help. Your Lordship summed up everything in para 26, then reply, and your court's view is from para 13. Kindly come to para 13 once. We are concerned with the appeal under section 37 of the Arbitration Act, 1996. The appeal is directed against the judgment and order of the learned single judge of this court, allowing an application of State of West Bengal for setting aside an arbitral award passed in favor of the appellant under section 34. What falls for our consideration is whether or not the learned judge acted within the parameters of section 34 of 1996 Act. It is established law by now that while exercising jurisdiction under section 34 of the 1996 Act, the court does not act as an appellate court. The learned judge does not sit in appeal over the arbitral award. The learned judge has to see, this is important. Learned judge has to see only if if the petitioner assailing the award has been able to make out at least one of the grounds for setting aside of an arbitral award as mentioned in section 34. In my case, not one, but in my humble submission, plenty of grounds are there.
আরেকটা কি আছে দেখো তো?
There's another one, Marut, that was with Justice Tandon. বলো judgment দাও আমাকে. Justice Tandon sitting with Justice Madhuresh Prasad. But I will not trouble your Lordship. This is regarding the development of some property near Ruby. South City. There was a joint venture and everything. All this came up. Eventually, my Lord, your Lordship will kindly say, kindly come to para 44. Tracing the development of law in this regard, the apex court held as follows. 40. Nevertheless, the decision in saw pipes versus ONGC holds the mere error of fact or law in reaching the conclusion on the disputed question will not give jurisdiction to the court to interfere. However, this will depend on three aspects: whether the reference is made in general terms for deciding the contractual dispute, in which case the award can be set aside if the award is based on erroneous legal position. B. This proposition also holds good in case of a reasoned award which on the face of it is erroneous on legal proposition of law and its application. And C. Where a specific question of law, I need to trouble. Then next paragraph. In Sawpipe's case, ONGC, the court set aside the award on the ground that the award has not taken into consideration the terms of contract before arriving at the conclusion as to whether the party claiming damages is entitled to the same. Reference was made to provisions of section 73 and 74 of the Contract Act, which relate to liquidated damages, general damages, and penalty stipulation. This view has held the field for a long time and was applied in subsequent judgments of this court in Hindustan Singh versus French Coal Carbonization, Contra Mineral Metals Incorporated versus Hindustan Copper, DDA versus RS Sharma, JG Engineers, and Union of India versus LSM Murthy. Para 41. In 2006, this court in McDermott International, despite following the ratio of saw pipes, made certain distinct observation regarding the restrictive role of courts in the post-tower interference. In addition to the three grounds introduced in Venushagar case was General Electric, as noticed above, an additional ground of patent illegality was introduced in saw pipes for exercise of the court's jurisdiction in setting aside an arbitral award. This court in McDermott's case, was one standard, held that patent patent illegality must be such which goes to the root of the matter. The public policy violation should be so unfair.
We have noted it, Mr. Ghosh. It's not
They're
necessary.
giving all the cases which we have
Yes,
cited,
yes.
same principles. I don't think that there is any, even in 2025, Willows, they are following. So in my humble submission, Willows, the award was rightly subsidized of the majority of it. And the trial court's judgment should be upheld.
After vacation,
After
your
vacation,
reply?
Reply and also notes, perhaps.
Hmm?
Written notes for you to assist.
You want to file written notes?
Yes, sir.
File. If you want to file, we are not directing.
Very
If you
good.
wish to file written notes, we can't
The day we give the reply, we shall hand over, my lord.
do that. Your senior in this matter has deserted you. Already gone on holiday.
He's stuck in
Code number 3.
Lego.
But only one thing, I have one request to your lordship, rather two requests.
Sorry?
I've got one request to your lordship, subject to lordship's, that I shall be going for knee replacement.
Oh, so when do you want it? Tell us.
Week beginning November, week beginning 10th November.
Yes. That is all right. Mr. Ghosh, learned senior counsel representing the respondent.
That, my lord?
Respondent concludes his argument. Paragraph lists this matter once again on November 12th
12th, my lord.
for the appellant's learned counsel to make submission in reply.
The matter should retain the position, my lord, and also, my lord,
Make
would
it part heard,
kindly
my lord.
just part heard. Yes, my lord, that's what. It's a one-line part heard. Otherwise, your lordship extensively heard this matter.
Yes, it's only very fag in now, my lord.
Paragraph on the request of learned advocates for both the parties, and since we have heard this matter in extenso over a considerable period of time, let this matter be marked as heard in part within the comma.
Very grateful.
So grateful, my lord.
Sorry, my lord, but
Yes.
on 12th, lordship was pleased to, my lord, fix. I'm sorry, my lord, but
12?
mentioned it's not Vizag matter, my lord.
If a singly sitting singly, how can I say?
I understand, my lord.
Mention when the division bench is there. Talk to Mr. Go.
I have already spoken to him.
Give us a date.
He has consented to a date, my lord, 26th of November. I will mention it tomorrow.
Great.
My lord, I beg to mention appellate side matter, my lord, for inclusion in the list. And I'm praying for accommodation for item number 4, 5, 6, and 10.
As you do always.
My lord, I'm pre-petition. This is my application, my lord.
Your application.
My application.
Even then.
As in 4, 5, 6, and 10 of appellate side list.
Why don't you withdraw it if there's nothing in it? Every day you say.
I have to take instruction from my client, my lord.
What? He's not giving you material instruction. That is why.
No,
yes,
my lord.
yes. করে দাও, যা বলছেন করে দাও।
4, 5, 6, and 10. Not today.
Not this month.
Not this month, my lord. After vacation.
Number 1 and 3, my lord. It is after vacation.
You are for?
I'm for the petition.
After vacation?
1 and 1 and 3.
পুরো লিস্টটাই after vacation। একটা লিস্ট দেবে আমাকে?
As favorite 1 and 2, not if it could be taken up after the vacation.
Yes.
So 1 and
What are you
2.
for?
For the state. For the state.
At 1 and in item number 1, I am for the applicant, your lordship. This is my recalling application of my lord's order.
Yes, Mr. Sinha is seeking an accommodation.
Yeah, I am not opposing.
We're
your
not
lordship.
opposing. He's not opposing. As requested by Mr. Sinha, learned advocate representing the state is a party.
State not has been now made a party.
Acha. Represent the state, huh? Let this matter be taken up, be listed immediately after the puja vacation.
Grateful,
Yes,
your lordship.
1 and 2 both.
Both, my lord.
I'm
Both.
for only 1, your lordship.
You're only one. 2 te dakho. 2, nobody appears.
I think she's there. She's there.
Same order.
My lord, immediately after vacation would be, my lord, actually what
Whenever I sit. Whenever I sit, at least 2 days in advance, it will be displayed.
For the petitioner, my lord, my application recalling of a decree passed by lordship, my lord. My lord has heard this matter at length, my lord. My seniors who are leading me, my lord. Now, my lord.
Yes, he's on this side now.
Yes, my lord. My lord, any day, my lord, fixes it all.
After vacation. Maybe this is a lucky matter. Argue it.
You'll be on that side.
There is advocate for the applicant. Applicant requests that this matter may be taken up after the puja vacation. Paragraph. Let this matter be listed once again after the puja vacation whenever I sit singly.
Great.
You are for?
I am for the petitioner, my lord. For this is that matter, my lord. That is the
Yes, Shotandar Mishtanu Bhandar.
Yes, my lord. My lord, till we had issued several notices to repay the shares. We have issued notices on my lord.
My lord, I'm appearing for the petitioner in this matter. This is the matter your lordship remembers the thought.
Yes, is now how many months?
My lord, they had paid last till June.
June.
Till June, my lord. Thereafter, we have written them letters. Right now, there is an outstanding due of 43,000 and odd. If your lordship will kindly take up the last 3 orders, my lord.
What's the use? They are not here.
On the last occasion, they were
Any
beseeching your
advocate for
lordship to get the contempt petition disposed of. But my lord, if this is the demeanor of the respondent, then if this is disposed of today, my client will have no other forum to go to and will be completely rendered remediless, my lord.
Learned advocate for the petitioners says that again the alleged contemnor is in default. Stop. As on date, about rupees 43,000. is payable by him to the petitioners. Paragraph, the alleged contemnor is not present. Stop. List this matter once again after the puja vacation whenever I sit singly. Paragraph. In the meantime, in the meantime, the alleged contemnor should make good the default and pay the amount to the petitioners as is payable in terms of the earlier orders of this court. Stop. If on the next occasion তারপরে লেখো, read order dated November 29, 2024, where I had recorded the following. কোলন দিয়ে এই আগের অর্ডারটা থেকে এই পোর্শনটা ব্র্যাকেট করে দিয়েছি। I find that the alleged contemnor is again in default. Stop. I will have no option but to pass very stringent orders against him, including holding him guilty of contempt of court if this continues.
My lord, just very small indulgence that I'm seeking before your lordship. This contempt petition is in respect of the revenue generated out of a sweet meat shop. Now, this is the case they are trying to run right now, that the sweet meat shop is completely closed. There is no revenue being generated out of it. So therefore, however, my lord, we have sufficient evidence to show that in the garb of this, from the back door of it, they are carrying on a vegetable vending shop. We have sufficient substantiation for the same, my lord. However, in this connection, my lord, for the same, may an order be passed for directing upon them to hand over the key with the registrar original side, my lord.
Not today. Let us see.
As your lordship pleases.
Next.
Grateful, my lord.
Number 5, Milord, I am for the petitioner, Milord.
Actually, I'm appealing for
As per the last order, Milord, we have done the corrections in the cost title, Milord. As per the last direction, Milord, we have done the corrections, Milord.
Lordship, I'm appearing for the respondent. A direction was there for payment of an amount of rupees 9 lakhs. That amount has been paid by way of a DD. That demand draft has been encashed as well. Lordship, I'm filing my affidavit of compliance.
And we have not
understand
received
what
any
the matter
affidavit.
is.
Milord, may I come back after vacation, Milord? They have given us a affidavit of compliance, Milord. I have to go through it, Milord, and take instruction, Milord.
Lordship, the demand draft has been encashed on 7th October 2024.
Like today, I am without instruction, Milord. May I come back, Milord?
On 26 September itself, last year, 26 September,
Yes,
they had said that they had complied with the order.
Milord, I have no instruction today, Milord. Milord, if
So why
Milord can,
are you appearing, sir, without instructions then?
Milord, they were supposed to file affidavit, Milord. I even sought instruction from the client, Milord, but in the passage of time, Milord, it was not given, Milord. So
Affidavit of compliance filed by the respondents in terms of my earlier order dated September 26, 2024, be kept with the records. Stop. Paragraph, a copy of the affidavit has been made over to learned advocate for the petitioners who seeks a little time to obtain instructions. Paragraph lists the matter once again after the puja vacation whenever I sit singly.
Lordship, one more indulgence. A security of 11 lakhs was given when we had filed that appeal. May we be given liberty to withdraw that security, my lord?
When you had filed the appeal?
Yes, my lord. Before the division.
You are for the ECGC?
Yes, my lord.
Your appeal was dismissed?
Yes.
How much was payable to them?
9 lakhs.
That you have paid?
That we have paid. The demand draft they have encashed also.
I'll pass that order on the next day, sir, not today. Bring the orders in terms of which you deposited the money.
Yes, my lord, that is forms part of my affidavit of compliance.
Very good, very good.
Item number 2.
এই মামলা করবে। কিন্তু কৌশিক গেল কোথায়? আজকে ইন্টারভিউ? ও ঠিক আছে।
Item number 7. Item number 8. Item number 9. Item number 11.
11 I am for 11 and 12.
Yes.
My lord, the direction was given to make payment and also is last occasion and also direction to make the file the affidavit relating to the what amount is due. My lord, that has not been done. My lord, since my lord information, my lord, amount is my lord, still their process under process. My lord, the 1 week time,
লাস্ট অর্ডারটা দেখি।
just 1 week after vacation, my lord, one matter has already done. I will submit it.
The affidavit, Mr. Maiti, learned advocate, Mr. Maiti, learned advocate for the petitioners, says that
some payment under
the affidavit that his clients were supposed to file in terms of my order dated March 14, 2024, is in the process of being prepared. Paragraph, as requested by learned advocate, list this matter once again after the puja vacation whenever I sit singly. Stop. An advance copy of the affidavit should be made available to the alleged contemnor and oblique or his learned advocate.
Next matter is same.
Same, next matter same.
Item number 13. Item number 14.
14, my lord, I am appearing for the alleged contempt number 2. My lord, may I be permitted to file affidavit of compliance, my lord? The order has been complied with.
They are not here. What was the order? Let's see.
Yes, my lord. My lord, pursuant to an order of this honorable court, my lord, DM was directed to decide the issue whether who is entitled to get the appointment, whether the private respondent or the petitioner.
Mr. Roy Mukherjee, let me see the order of
Yes.
which contempt violation is alleged.
My lord, page 56, my lord.
Of the contempt petition.
Yes, my lord.
Rahul?
My lord, relevant is at page 69. This was filed by this writ petition was filed by the private respondent challenging the decision of the district magistrate. Your lordship was pleased to observe that the district magistrate's order is in order, my lord, doesn't suffer from any illegality.
This is the order of which violation is alleged.
Yes. Yes.
I had only dismissed the writ petition.
Your lordship was pleased to dismiss the writ petition. Then, my lord, the private respondent preferred an appeal. That your lordship will find at page 72. At 73, there was an interim order. The second paragraph. We make it clear that if at all the respondent number 7 is engaged as para-teacher in the concerned madrasa, such engagement and her continuance on the said post till the appeal is disposed of shall be without prejudice to the rights and contentions of the parties in the appeal, and the respondent number 7 shall not claim any equity at the final hearing. Thereafter, my lord, the final order passed by the Honorable Division Bench is at page 76. This is dated, judgment and order dated 25th of July 2023. My lord, relevant is at page 77, last paragraph, my lord. Your lordship's order was upheld, my lord.
All I am asking, I had not given any direction in the order. I had merely dismissed the writ application.
Exactly. There was no direction. Now he has been appointed, this lady has been appointed. Now she is asking for arrear salary. But none of the court, my lord, passed such direction.
You are for whom?
I mean, DM, your lordship.
Alleged contempt number 1, district magistrate, who is the authority.
You are for whom?
For director, Paschim Bongo Samagro Shikha Mission, there was no direction upon me. I have been made party respondent to this contempt proceeding for the reason best known to my learned senior friend, my lord, appearing for the petitioner.
I still don't understand. How would a contempt lie of my order where there is no direction?
My lord, that is the question, my lord. That is the question. My lord, time, I do not know, my lord, why this contempt was filed immediately, my lord. She was engaged. Now, my lord, your lordship will find from one order. My lord, this was pointed out before your lordship. Kindly, your lordship takes up, my lord, the order passed by your lordship 29th November 2024, my lord. It will be in your lordship's file. 29th November 2024 order. It was submitted, my lord, by the petitioner seeking, my lord, arrear salary. 29th November, my lord, kindly consider the last paragraph, paragraph 4.
How will I decide that in this contempt application?
Yes, my lord. It cannot be, and my lord, the principle is, my lord, no work, no pay, my lord.
I'll dismiss the application for default. Let's not get into it. এটা কি ফার্স্ট কল হচ্ছে তো? সেকেন্ড কল করো। Just be here for 5 minutes.
Second call. Pass over matter. Item number 2.
Usual dismissal, huh? Later.
Item number 7.
Same,
Item number 8.
same,
Item number 9.
same.
I'm for
9.
item number 9,
Here?
and I'm for the petitioner.
Yes.
Kindly take up the matter after vacation.
Very well. On the request of learned advocate for the petitioner, let this matter stand adjourned and be listed again after the puja vacation whenever I sit singly.
Item number 13.
Dismissed.
Item number 14.
Affidavit of compliance filed in court today be kept with the records.
By the alleged containment number 2.
Affidavit of compliance.
May I file this affidavit in opposition?
Opposition. Lekho affidavit of आगे lekho affidavit of opposition. Affidavit in opposition. Of the respondent number 1.
1 year.
Filed in court today be kept with the records. Stop. Affidavit of compliance filed by the respondent number 2 be also retained with the records. Paragraph. In the first call, nobody appeared for the petitioner. Stop. In the second call also, nobody appears. Stop. Paragraph. CC such and such, CPAN such and such is dismissed. Stop. Interim order, if any, comma, stands vacated.
Grateful, my lordship. The petitioner is on legs in another court right now. I was just
Petitioner
advised
is
by the
on
client.
legs.
In another court, your lordship. I was just advised by the client.
After vacation, come back. Let us see. Mr. Bhandari was appearing. তাহলে এটা করো affidavit গুলো নিয়ে নাও নিয়ে লেখো next accommodation is sought for on behalf of the petitioner. Let's list the matter after the puja vacation whenever I say.
Grateful.
Same.
Grateful, your lordship.
আসবো 3:30 সময়।
What judgment, item number 1.
Lord, may we permit to mention one appellate side matter?
This bench,
Yes, this bench. Lord, I'm extremely sorry. I beg to be excused to mention one contempt application in the appellate side, which was mentioned on 22nd July. During the period of 2 months, Lord, the Honorable Division Bench is found sitting for the 4th time. The Honorable Division Bench is found sitting for the 4th time, but this is unfortunately not appearing in the list. Considering the gravity of the urgency, your lordships was pleased to direct the opposite party to make the ad hoc part payment. Considering she is in ailing condition, 89 years old. She is
very well. Let the matter be listed. We'll see, sir. এটা কোনটা? এটা তো রেগুলার লিস্টে যেটা তুলে দেবেন। জাজমেন্ট তো দুটো আছে। Original side matter, Pankaj Plastic.
Yes, I appear for the appellant. Your Lordship.
Respondent is not there.
No. Mr. Dashgupta is leading me. He is appearing online.
We have dismissed the appeal, but we have clarified that rejection of the plaint and dismissal of the suit is only on the ground of non-compliance with the mandatory statutory provisions of Section 12A and not on merits. It will be open to the plaintiff to file a fresh suit on the self-same cause of action after following the statutory mandate contained in Section 12A of the Commercial Code.
May I make just one prayer? May the court fees be returned and may we have the liberty to prefer a fresh suit on the basis of the court fees?
এটা কি করে কেন কি sorry, no, not today. You make an application for that. You make an application, we'll consider it.
My lord.
Yes. Initial করলে তারপরে
certified copies. My lords, I'm so sorry to trouble you, my lords. I'm told that since the appeal is being disposed of, perhaps an application and a disposed of appeal may be a difficulty.
Liberty to file the appropriate application.
Very well. At a near now, after the judgment is delivered, learned advocate for the appellant submits that the court fees should be returned for being used for filing a fresh suit. Stop. The appellant will be at liberty to make an appropriate application in that regard.
I'm grateful.
Which will be in that regard, which will be considered in accordance with law. এটাকে add later বলে এরকম থাকে হ্যাঁ
I'm extremely grateful, my lords.
কেন রাখবেন না কন্টেম্পট এন্ট্রি
Appellate matter, item number 1 for judgment.
It's both the appeals are dismissed.
Your appeal. Yes. Your appeal. Yes. Did you expect anything else? No, correct. Daku. You had concluded, Mr. Mitru. You had concluded. How long? Conclude today anyway. Conclude today.
Yes, yes. Milord, try to conclude by 4, Milord, or 5
Yes,
past 4.
because we have an invitation at the Bar Library Club, in case you're aware of it.
I am aware, Milord. Because of the person concerned, I would have not wanted to attend, but I have to go.
I was, in fact, my lord, seeking for an order of injunction.
Against him, restraining him from leaving.
I have to go to Odisha, but then before an order is passed on me, Milord, kindly, Milord, pass a mandatory order on Mr. Ratnanko Banerjee. He's already there. He's my other side.
He cannot come.
That's why mandatory order. He should be brought back.
Very well.
My lord, on the last day, my learned friend had given my lord a copy of a judgment. My lord, I said I shall deal with it in a supplementary notes.
Yes.
May I file that?
Yes, yes.
ওদের কপি দিয়েছো?
If something else you may want to add.
What is he saying? Naughty boy.
I'm saying that, why are you doing it tomorrow? If you want to add something, why don't you do it?
After the vacation.
No, just tomorrow. Just
After
tomorrow.
hearing him.
After hearing him.
But you won't be here.
Tomorrow? No, but I'll come back day after. And I'll finalize. I've written the note.
But as we indicated, I think we'll keep this on another day immediately after the vacation, in case we have some clarificatory.
That I want to argue one point in reply to my learned friend's argument that the strict mandatory provision of Order 11, Rule 1, Sub-Rule 5 applies. That I just somewhere, my lord, it was coming to us that, my lord, that it's why should it be applicable to me and why should it apply on all fours? And we kept, my lord, thinking, Lord, kindly take the Commercial Courts Act once, my lord. And I'll just quickly, my lord, run through, my lord, the issues in reply and close.
This is a commercial cause.
Lord, it was filed in Balashat Court in October 2014. It was transferred on 5th of September 2020.
1 second.
The 27th October 2014 suit was filed before the learned court at Barashat. By an order of 5th September 2020, the suit was transferred.
Yes.
Now, my lord, I'm sorry, by an order of 12th July 2019, suit was transferred. In September 2020, my lord, the records reached.
19.
Yes, my lord.
5th September 2020 is the date of what?
The record will.
Record reached. My lord, because after September 19, my lord, from March 20, I think we were paralyzed. So in September it went.
To the commercial court.
Nobody's challenged the commercial court order. I'm sorry, nobody's challenged the order of transfer. But
yes,
I humbly submit there is no question of estoppel. It has to be, my lord, suit, my lord, in respect of an immovable property has to be used, in use, being used for, my lord, exclusively for commerce. This is fallow land. The relevant date, my lord, is the date, my lord, of the, my lord, document.
you're arguing a new point. He has to address this point.
So, my lord,
But a point which goes to the root of the matter,
yes,
perhaps.
this is what I thought I should indicate. Your Lordship may say, why did you keep quiet from 2020? Yes, I've accepted it. Your Lordship may hold that I'm not entitled to take the point, my Lord. But I think I should tell your Lordship this, that after all, my Lord, it's void. I am challenged, my Lord, what has happened? Allotment of land. Fallow land, which was, my Lord, marshy land converted into, my Lord, fallow land. And that's allotted by HITCO.
Which is the Supreme Court says actual use.
Ambalal.
Ambalal.
And my lord, there are at least 2 judgments of the division bench which also say the same thing. Actually being used. So my lord, as at the date of conveyance, it's not being used. It's, my lord, cows grazing. Yeah, and that's the relevant date. That's the conveyance which is under challenge. Date of allotment, date of conveyance.
Property used exclusively. Used কথাটাকে interpret করেছে proposed to be used.
Not very fundamental, and there can ever be no estoppel. By consent, you cannot confer jurisdiction. This is number 1. Number 2, Lord, please have a look at Order 11 as amended. I won't read, my lord, but Rule 1 is that when you file a suit, you have to file a list of all documents within your power, possession, control, and custody pertaining to the suit along with the plaint. Order 11, Rule 1. Along with the plaint. This is, my lord, the first imposition.
List of documents.
Yes, list of documents and photocopies of all documents in power, possession, control, and custody pertaining to suit along with the plaint. And documents referred to and relied on by the plaintiff in the plaint. B, documents relating to any matter in question in the proceedings in the power, possession, control, or custody of the plaintiff as on the date of filing of the plaint, irrespective of whether the same is in support of or adverse to the plaintiff's case. Then, my lord, the relaxation. Now, my lord, sub-rule 2 is what the list must specify. That's not so relevant. Sub-rule 3. Plaint shall contain a declaration on oath from the plaintiff that all of it is there. And yes, there is no other document. And the explanation is not statement of truth under rule 3, sub-rule 3. So, Milord, plaint with a list with all these declarations, all documents pertaining to the suit, whether for or against you. That's Milord red fund procedure. Now come to 4. 4, Milord, is you have a 30-day window, provided on day 1 you come and obtain a leave. Very urgent, I can't get all the documents, I get a leave. With this imposition comes 5. That after this you can't, sub-rule 5, Milord, plaintiff shall not be allowed to rely on any documents which were in the plaintiff's power, possession, control or custody and not disclosed along with plaint or with the within the extended period set out above, 7 except by leave of court. Now, Milord, I have filed before the civil court. 1, 2, 3 and 4 did not apply to me. I have filed before the Commercial Courts Act. If, Milord, 1, 2, 3 and 4 don't apply to me and they all apply at the time of filing of the suit, then the imposition of 5 should also not apply on me. Milord, this is A is a direction, this is what you must do with the plaint, and B is a consequence. What I had to do with the plaint was not relevant when I filed the suit. It wasn't there. None of us knew that there would ever be a statute requiring this kind of strictness when we filed in 2014. Now, if my plaint is filed in 2014, then why should 5 apply to me is what I ask myself. And I humbly submit it should not. Milord, procedural, it's not settled now that procedural matters, Milord, which apply retrospectively, after to transferred suits, the procedure will apply, procedure of the commercial court will apply. It's settled. I don't want to, Milord, go back on that. But something like a written statement, your lordship will take it 120 days from transfer. You're giving me that benefit of 120 days and from the date of transfer. Act is there, you know. And now this procedure applies in 120 days, there'll be a guillotine. But in Order 11 is a peculiar set of, Milord, rules where based on my initial compliance at the time of filing of the suit is, Milord, that's the genesis. And based on that, Milord, is the consequence under sub-rule 5.
No, but if you succeed on your point that this could not have been marked as a commercial cause at all, then none of this is.
None of this will apply. But even if your lordship settles the law on this, that in case of a transferred suit, when a plaint is filed without having regard to 1, 2 and 3, then why would 5 apply after transfer of the suit? Other provisions may apply, but this, Milord, should not apply. Because I didn't have, Milord, 1, 2 and 3 to comply with. Nobody's dealt with this issue. Secondly, your lordship may, Milord, feel that after transfer, you filed a statement of truth in compliance. Let it apply from that date. But even if that is the position, the statute has to, Milord, say that from the date in respect of a transferred suit, from the date of statement of truth, you are precluded from disclosing further documents. My lord, I humbly submit that I'm reading into a statute when I say that the embargo under sub-rule 5 will apply from the date of filing of the statement of truth. The provision of transfer doesn't say so. No other provision in the Commercial Act, Courts Act says so. There are other courts which have, other high courts, my lord, which have held that Order 11 sub-rule 1, sorry, Rule 1 sub-rule 5 does apply to transfer. I found a judgment. Does apply. But this issue has not been held, not been dealt with. I couldn't find a single Supreme Court judgment on this. This issue, Order 11. Provisions apply after transfer accepted. But what about a provision which is contingent upon something prior to transfer?
How will that be relevant to this appeal at the moment?
It is relevant because this is the genesis. What has happened here? From the day when both of us applied for disclosure of documents. We wanted to do the suit. We could not put in all the documents pertaining to all those fraudulent allotments and the minutes. The learned judge and my learned friends wanted all the board resolutions, etc. My learned friend's application is forgotten by the learned judge. My application is picked up and not dismissed.
Yes, your conduct, what the defendant has tried to demonstrate, is your very, very unhappy conduct.
That I have been taking adjournments in the suit.
Killing time, prolonging the matter without justifiable cause. This is what their argument has been.
Yes. It is a compelling argument.
But if you want to develop on the fact that this couldn't have been marked as a commercial cause,
that I want to show that judgment.
No, HON'BLE, we are aware of HON'BLE. Other judgments, whatever there is.
No, there is enough. But even now, let me, I know your lordships have been shown those orders from 2014. But what your lordships have not been shown is an order by which what had happened was when when suit became effective again, first order passed by the learned commercial court was, I'm going to dismiss your suit because of all this delay. And order was also passed, against which we came up in revision and we had that order reopened.
What order was passed? Dismissing your suit?
For delayed revision. I'll just show you a lot.
Against the dismissal, you came up by way of revision.
No, not dismissal of suit. Yes, dismissal of order 11, rule 5, and I think order. I'll just page 843 in volume 6. Please see 843. First day when we filed this application, মনে পড়ে গেছে। Just 2 sentences. Your lordships have been shown, my lord, a series of adjournments from 2014 till 2024. The only answer, my lord, I can possibly give your lordship is Number one, my lord, the same issues were being decided in the High Court. My lord, and it was continuously happening. Writ, appeal, same issue. And neither of the parties wanted this to be proceeded with. Nobody had done anything. My lord, please see page 843. Now for this, when I moved my application was picked up and this was the order passed. Learned advocate for the plaintiff appears and files Hazira along with an application under Order 11, Rule 5, read with Section 151 of CPC, praying for seeking leave to disclose additional documents on the grounds stated therein. Copy served. Learned advocate for the defendant appears and files Hazira along with fresh judgment. Learned advocate for the defendant also files an application under Order 11, Rule 14, read with Section 151, praying for passing of an order giving direction upon the plaintiff to disclose, furnish, produce, not documents. This is the only reference to my learned friend's application. Then, heard both sides, perused application as well as case record from where it transpires that today's fixed for PH plaintiff did not file affidavit in chief since 5th October 23 and has filed the said application at the stage of PH. Plaintiff has remained silent since 22 till 4th August 23 in filing application at the state of case management hearing. Considering the facts, I am of the view plaintiff is unnecessarily dragging the suit which is still pending since 4th September 2020 after being transferred to this court for dispute disposal. Hence, application under Order 11, Rule 5, read with Section 151 is rejected being infructuous and plaintiff to file show cause as to why suit should not be dismissed for default. That's not proceed, not for non-prosecution. We will not challenge this order.
You only praise this order. We have noted it.
Yes. Next page, Milord. This is, Milord, set aside.
Yes, 28th May.
Yes. Then, Milord, the learned judge accepts the cause shown. Suit is not dismissed. So, Milord, if my suit is not dismissed, the learned judge accepts the cause shown. Then, Milord, am I to again be prejudiced for what I have succeeded once in convincing the learned judge? And nobody was doing the proceeding. Milord, because matter was, the same issue was being considered. All records were in court.
Argue your fundamental point.
Yes, Milord, I have sent for the judgment. Milord, I will
because
do
that
that.
will set everything at naught.
Everything goes. Everything goes. And there can be no estoppel, nothing. No amount of consent can give a court jurisdiction. Milord, please have a look at the plaint once, Milord. Milord, I'll just two. Now, please see page 329. Volume 2. We'll try, I'll try my absolute best, Milord. One man cannot have the benefit what everybody else in Newtown, Milord, has not had. And he was a special man then. One day before the decision, he got his conveyance. Milord, we will try our level best, Milord, to convince your lordship.
I don't think he is concluding. May I come back?
Come back. Or don't come back as the case may be, because we will rise in 15-17 minutes.
The way Mr. Chaudhary is proceeding, I'm certain that...
At this point, Mr. Mitru will permit him to allow. This is goes to the root of the matter.
I shall. Job ইচ্ছে রাখবে না আমার কি আমি থাকি আমি বাইরে কেউ নিয়ে যায় না স্যার চলো
After the vacation, we'll fix a date.
Yes, my lord.
any day
Mr.
I'll be there any day
In the second week or third week, you go out, consult him, get a date.
any day
Any day.
I'll be there.
That if your lordship sees the plaint, Thompson, no, চট করে। Milord, please see, Milord, the plaint, page 330.
Yes.
Milord, page 330 in volume 2.
This is part of what?
Milord, this is the plaint, Milord.
But this is the plaint.
Yes, Milord. Volume 2.
330 with reference to the averments, etc.
এটা বোধহয় অন্য ভলিউম চলে গেছে।
সাপ্লিমেন্টারিটা দিয়েছো একবার দেখুন সাপ্লিমেন্টারিটা চলে গেছে
ওটা থেকেই বলো না কোথায় আছে।
This is the supplementary.
That's filed by us.
Oh, that is the additional documents which my learned friend wanted to. Main paper. এইটা
ভলিউম 2 তে হবে বোধহয়
সন্দীপ দাশগুপ্ত
Yes.
P29 থেকে শুরু। হ্যাঁ
The interview. কিছু একটা পরীক্ষা promotion হয়। ও শিখে গেছে। ও আচ্ছা আচ্ছা।
Milord,
আমার নতুন করে আর
তোমার বন্ধু আমি চলে যাবো
এখন সমস্যা হয়ে গেছে।
Paragraph 2, Milord. ITCO was constituted with the object of development of new town, green, eco-friendly, planned city. It was nothing before. Now, Milord, plaint. Paragraph 3. Milord, again, development of all these facilities. Then, Milord, paragraph 4 at page 332, with the objective of creating new town. Housing department decided to acquire land for the purpose of development.
No, Mr. Chaudhary, will it be disputed by them that as on the date of filing of the suit, the land was not being actually used in trade or commerce?
Cannot be. Nobody can dispute this.
If that fact is admitted, then it becomes a question of law then.
It's a pure question of it cannot be because this is a first on allotment. This is acquired land. This is all land acquired, filled up by IRCON, and then, Milord, this is allotted by chairman's quota to special people.
we have shown my lord the deed specifically provides that it has to be commercial.
Yes,
This
it
will be.
proposed. Proposed. That is the point, Mr. Mitro. Now this Ambalal, at least that one I remember.
Yes.
look at it carefully.
How it was used, how it is being proposed to be used. How it was being used is blank. It was not being used either residential or commercial, nothing.
At all.
At all. Now, so my lord, the first part goes. The second part is.
Would it come under 2(1)(a)(7)?
I shall. Absolutely.
That is the only point.
That's true. Today, they are taking this point, my lord, point in desperation, according to me. This point was never taken.
No, quite
Correct,
right.
correct. I agree with you.
From the very beginning, they accepted this.
But if
Now,
it's,
finding difficulty, this point is being
if
taken.
it's a question going to the root of jurisdiction,
I shall address you.
The provision says, agreements relating to immovable property used exclusively in trade or commerce. And this, my lord, is interpreted in Ambalal to mean being used. Paragraph 37. A dispute relating to immovable property per se may not be a commercial dispute, but it becomes a commercial dispute if it falls under subclause 7 of section 21C of the Act. Agreements relating to immovable property used exclusively in trade or commerce. The words used exclusively in trade or commerce are to be interpreted purposefully. The word used denotes actually used, and it cannot be either ready for used or likely to be used or to be used. It should be actually used. Such a wide interpretation would defeat the main objects of this act. And from then, my lord, plethora of my lord plaints were rejected because we didn't read it as actual use. My lord, for example, an agreement for sale in respect of a property, 95% commercial, 5% residential. Agreement for sale of a property, 95% of the property is for commercial, 5% is for residential. Proposed, my lord, use is, my lord, purely commercial. Even that will not be a commercial suit, because it must be used, or it must be being used exclusively for commercial purposes. Lord, this is the interpretation.
Ambalal is 2024.
Supreme Court cases.
2024.
2020.
2020.
Yes.
There must have been subsequent Supreme Court cases also.
I am not, my lord, aware, my lord.
2020, volume 15.
Supreme Court cases 585.
585.
I am aware of, my lord, one judgment of the division bench of this honorable court where, my lord, Ambalal was considered, and, my lord, this interpretation was accepted.
Do we have a choice, Mr. Chaudhary, whether to accept or not to accept?
No, because I had, my lord, placed this, and it was, that's, my lord, actually. So, my lord, this is, my lord, reported in Manupatra, and, my lord, a journal called ICC.
Indian civil cases.
Yes, which Mr. Mitra used to subscribe to at one point of time.
Mr. Surajit Mitra?
No, my senior, my lord.
Mr. Abrujit Mitra.
I used to go and get it.
What is that ICC citation?
Indian civil cases.
No.
This is, my lord, 2023, volume 4, ICC 553. Paragraph 15, my lord, in Ambalal Sarabhai, the words used exclusively in trade or commerce are to be interpreted purposefully. the word used denotes actually used, and it cannot be either ready for use or likely to be used or to be used. It should be actually used. Such a wide interpretation would defeat objects. It's quoted. It thus makes it clear that a dispute relating to immovable property simpliciter will not amount to a commercial dispute unless it is also actually used exclusively in trade and commerce.
In present time.
In present time. So, the date of the allotment, this was unused land, fallow land, ready for allotment.
T. Thompson and reference it with actual সেখানে
The judgment, whether 106 is a statutory right or the T. Thompson, which was referred to a division bench, that's also reported in T. Thompson and Company,
Oh, Justice Shobhosaj, Justice Krishna Rao.
That's reported in Manupatra. I'll hand up copies.
Copies, yes.
Yes, by today, I'll do that. Here also,
present item 110.
And paragraph 110 of the Manupatra print is exactly what fell from your lordship in present time. The narrow and restrictive meaning was confined to the user of the property exclusively for trade and commerce, and there has to be a finding of fact that the land is in fact in present time being used for commercial purpose. The aforesaid decision in paragraph 14 has made it clear.
P. Thompson, what is the case?
Yes, the T. Thompson versus Swarnalata Chopra.
This is the division bench. Justice Sen.
Justice Sen. $110 and $111, Millard. Other high courts, Millard, have also, and this is time of file. Here I would take it back to, Millard, the allotment. So that's under challenge. That legality is under challenge. So, Millard, this is a fundamental matter. Now, Millard, my learned friend's only argument, and I would humbly submit, his only argument has been, you have delayed, and therefore this is a consequence. I want to, Millard, take your lordship through the orders. Again, quickly, Millard, to point out a few orders to show that, yes, it is plaintiff's obligation to proceed with a suit. Undoubtedly so. But at the same time, number one, the defendant has never objected. Defendant also did not want to proceed with the suit. And this common, did not want the suit to be decided. And this common, situation was, there were 80 writ petitions on the same subject being heard by the High Court and in appeal. This is not the most fundamental issue. Yes, it's a practical submission. Doesn't take away plaintiff's right. But if your lordship looks at it from that viewpoint, that plaintiff's obligation is to proceed, you have come late. Then, my lord, I want to break it up into, my lord, 3 parts as I did last time. 14 to 20. Matter was before civil court. 20 to 24. Firstly, my lord, main issue was being decided. Then, my lord, main issue. Then, my lord, order 7, rule 11. That, my lord, these just 4 years. The day this ends, within 7 days, I am before the court with my application, and so are you. And, my lord, please also, my lord, read this with my lord, a very prejudicial fact for my learned friends, that when you went the court, when I went, the court, my lord, said, I will non-suit you for your delay. I had that order set aside. This application was dismissed. I had that order set aside. And I went back to the court. Then the court accepted and said the cause shown and said the suit should not be set aside. A suit should not be dismissed. And we have not taken an adjournment ever since. No, we haven't. We have been closely doing the matter. We've been, both of us have been appearing. I know. Maybe one day, if they search really hard, they'll find out. Otherwise, nobody's taken. I remember the learned judge was not unwell. We went so many times and came back. That's not, let's not get there. I'm quite certain. After Milord, the order 11 debacle, Milord, there's been no adjournment. Now, Milord, two crucial facts. He wants documents also. That's Milord ignored. And my reason to disclose documents arise, Milord, 1 year back because of his order from the Supreme Court. Till then, I would have shown writ court judgment and appeal judgment, and that is binding inter partes. I need not have gone into issue of other allotment. It's not that gross if your lordship looks at it very objectively. It's not a plaintiff who has done nothing. Same plaintiff was arguing the same point here.
This allotment was specifically kept outside the purview of the writ petitions, wasn't it?
No, my lord, may I bring it to your lordship's notice?
Because there was a.
Please let me.
I'm sorry to
please,
interrupt.
Mr. Mitra, don't
On the
cut my
contrary,
flow.
the writ petitioners, my lord,
No, that he's
the
arguing.
writ petitioners implemented me and this claim to us that I
wrong.
stand on a.
My lord, writ petitioners came and said,
He is
you
wrong.
have
That's
not,
staying in the Justice
you have
Banerjee.
not cancelled the allotment of two special people, Alo I Care and Balaji. We said that no, because there are executed conveyances. We have filed suits. And if ever I come to your lordship and request your lordship to certify that I am temperamentally sound, I would reasonably
Unhesitatingly.
Kindly also tell us that we are also temperamentally sound. To accept something, you know, that the plaintiff
strategy
can,
used to be sound.
in
Give
reply,
us a date. Let us add that.
My lord, may I?
Yes.
in reply, he can reopen everything.
May I have your lordship?
And we
Mr.
have to
Chatterjee,
accept.
assist Mr. Mitra on that point, fundamental point. We haven't heard you on this point.
With leave of my learned senior
No,
friend, while we submitted
Two
that,
things are fundamental. You are a man who is so special that you have got a conveyance one day before the board resolution.
That you only executed the conveyance.
Yes, but
he's accepting that.
number two is that this debacle wouldn't have happened where this honorable court passes an order, you're at liberty to go and ask for an adjournment. Learned judge ignores that and delivers decree. What is the value?
এটা নাও, এগুলো নিয়ে নাও। দেখো, Mr. Jishnu Chaudhary, learned senior counsel, begins his argument in reply but does not conclude. Paragraph lists the matter once again on give us a date after the vacation.
Mr. Chatterjee doesn't come back to India very.
No, I am here even during the vacation bench, Milord. If your lordship wants to do it, Milord, I have no problem.
This is Mr. Paja used to do this. Mr. Ajit Paja used to do this.
করো বাবা। On
24.
for the time being, what? We have fixed several matters on 24th actually.
3 p.m. Milord.
Before the regular bench. Let us keep it on the 6th of November.
2 o'clock.
We do not know many things, whether determination, of course, this is part of it.
Milord kindly keeps it at 2 so that he can finish in 1 day because he's going to start off again from the
Not
first.
two, marked. That we'll decide. 3 or 3:30, we'll later decide.
Grateful.
6 তারিখে? তাহলে 6 তারিখে দেবেন না। Then what about 12th? Look at the diary. 12th, আপনি বলেই দিন 3 o'clock বলে দিন। Mark 3 p.m. বলে দাও। এই মনে রাখবেন বেঞ্চটা কনস্টিটিউট করতে হবে। নিয়ে নাও এগুলো, নিয়ে নাও।
আজকে কোথায় যাবি? আজকে কোথায়?
Back because the learned judge was unwell.
I make no aspersions against.
No. Not entirely different query. Has nothing to do with the merits of the case. Were those strips effective or not?
Always.
Of course.
Always.
Hitco.
Mr. Chaudhary, not Hitco.